on international settlement agreements resulting from mediation. That, to many, is the New York Convention equivalent for mediation. It came into force on the 12th of September, 2020, I believe. But has it achieved, would it have the same effect as the New York Convention? The New York Convention came in 1958. Today, it's still a principal instrument for international commercial arbitration. Would the Singapore Convention have the same effect? I don't want to steal the thunder of any of the speakers, so I don't want to impose my own views on our discussion for the moment. So I will just merely introduce our speakers so that we can get the ball rolling. You already have a brief profile of all the speakers, so I'm not going to spend any time in making any lengthy introductions. I'll merely introduce them as they are about to come on. But it suffices to say that on the panel today, we have my Lord, the Chief Judge of the Federal Capital Territory, Mr. Justice Bello. We have an experienced international mediator, solicitor, Jane Gunn. We have Chief Emeka Obegulu, who is an arbitrator and the president of the Chartered Institute of Mediators and Conciliators, I think. And we have a solicitor, Imani Khalifa, who is in Freshfields, Brockhouse and Deringer. And I'll give the full bios as we go along, as I said. But to kick the ball rolling, I would like to call on our own Mr. Dr. Agada Elachi, who will give us an overview. Agada is a fellow of the Chartered Institute of Arbitrators, is a consultant and facilitator of the dialogue and mediation process of the ECOWAS Commission, is the chairman, head of Alternative Dispute Resolution Group of the Nigerian Association of Chambers of Commerce, Industries, Mines, and Agriculture. Interestingly, Agada has a PhD in conflict studies, which that's interesting. We're talking about mediation. You also have somebody who has a PhD in conflict studies. So not to take too much of your time, Agada, I yield the floor to you. Please give us an overview of the Singapore Convention.
Thank you, Mr. Belgore, Senior Advocate of Nigeria. My lords, fellow panelists, distinguished members of the audience. My task in the next few minutes is to quickly give a background to the Singapore Convention on the Enforcement of Mediation Agreements. Is a third-party process. It's a dispute resolution process in which a third party assists the disputing parties to reach.
I think we're losing you, Agada.
On their own terms, in simple for the parties in the dispute, they decide. Hello?
Agada, you might have to go back a bit. You might have to go back a bit, okay, because we lost you for some time.
Okay. I'm just saying that by way of background, mediation agreements generally are, by way of statistics and by way of background, are generally complied with by parties on account of the fact that parties usually reach this agreement on their own terms and by themselves. However, there are, of course, instances where agreements need to be enforced. Now, the challenge with enforcing such agreements in the sense that while the process of mediation is non-binding and the outcome is binding, the outcome generally at best is a contract between parties. Before now, you would have to begin the process of going to court and get the court to recognize the agreement and then order specific performance of that agreement. Level multi-door courthouses, that's ADR, court-connected ADR centers. We now have the establishment of what you call the ADR judge, who will then endorse the agreements reached as a judgment. On the international scale, greater challenge until the advent of the Singapore Convention on the Enforcement of Mediation Agreements. Now, in a 2014 survey conducted by the Mediation Institute, International Mediation Institute, the results showed that 93% of the respondents will be more likely to mediate a dispute with a party from another country if that country had ratified the Convention on the Enforcement of Mediated Settlement Agreements. So basically, that survey helped to drive the process that led to the convention that we have today. In December 2018, the United Nations General Assembly adopted by consensus the United Nations Convention on International Settlement of Agreements resulting from mediation and recommended that the convention be known as the Singapore Convention on Mediation, otherwise generally referred to as the Singapore Convention or the Convention. And of course, authorize the signing of that convention to be held in Singapore on the 7th of is the Singapore Convention. Now, the convention for the facilitation of international settlement agreements resulting from mediation by ensuring that settlements reached by parties is simplified and streamlined procedure. And the whole idea is to encourage international people who are involved in international commerce, international trade, to embrace mediation as an option to resolution of disputes side by side with arbitration, which of course is much more popular. Now, what are the key features of the Singapore Convention? And I'll run through them. The types of mediation to which the Singapore Convention would apply. Importantly, the application of the Singapore Convention is limited to commercial disputes, which are international. And that is the key thing to note, that it's limited to commercial disputes, which are international. And of course, just as the moderator, Mr. Belgore SAN said, this then makes the convention to the Singapore Convention to mediation is what the New York Convention is to arbitration. So whilst the Singapore Convention is limited to commercial disputes, it also talks about certain disputes that are excluded from the operation of the convention. And some of them are, for instance, agreements arising from transactions engaged by one of the parties for personal, family, or household purposes. So where it is for personal, family, or household purposes, the Singapore Convention does not apply. Also, if it's relating to family inheritance or employment law, for instance, divorce and all that, the Singapore Convention would not apply. If it relates to, and this, I guess, is the area which my Lord and Chief Emeka Begolo would be interested in commenting on, is which also relates to, does not apply to agreements which have been approved by a court or concluded in the course of proceedings before a court and are enforceable as judgment in a court. And lastly, it does not apply to recorded or enforceable or agreements that are recorded and enforceable as an arbitral award. For instance, an agreed consent award in that regard. So the Singapore Convention excludes all of this. Now, of course, the convention also defines in Article 2.3 what mediation is. And it says basically that the definition of mediation is an attempt by parties to reach amicable settlement of their dispute with the assistance of a third party or persons, who is referred to here as the mediator, and who lacks the authority to impose a solution upon the parties. The key thing to note from the provisions of the convention is that the convention also recognizes that even if the agreement or the process through which the agreement is arrived at is not necessarily referred to as mediation, that agreement still will apply within the framework of the Singapore Convention. There are certain formalities within the convention. For instance, Article 4.1 sets out some formalities that must be fulfilled before enforcement, relief or enforcement can be granted in compliance or in reliance of the Singapore settlement agreement. Some of the requirements, for instance, are that the settlement agreement must be signed by the parties. It must be in writing and must be signed by the parties. And then the settlement agreement there must be evidence that the settlement agreement resulted from mediation. Now, to achieve this, of course, the convention, all that may be necessary to evince that the settlement was from a process of mediation, all you may need to do is to have a mediator sign along with the parties to indicate that this was a mediator settlement, or if it was a mediation conducted within the auspices of an institution, for instance, like a multi-door courthouse, then of course, that institution endorsing that agreement, that will suffice in that regard. Issue to note from the Singapore Convention are that there are grounds for refusing the enforcement, and these are provided for under Article 5, and the grounds are quite exhaustive. And so an enforcement or relief or enforcement will not be allowed or granted if a party to the settlement agreement, for instance, was under incapacity to have entered agreement in the first place. Another basis on which is contrary to public policy. Then, of course, if the subject matter is not capable of being settled by mediation, that is also another ground for refusing relief or enforcement. The settlement, also another ground, is where the settlement agreement is null and void, inoperative, or incapable of being performed under the law to which it is subject. So, a key thing to note, especially with regards to the convention, is that if you enter the agreement in one country and you seek to enforce it in another country, you need to make sure that the agreement is enforceable within the law, under the law in which of the country where you seek to enforce it. Another basis could be the settlement is that the settlement agreement is final according to its terms. And this can be judged by looking at the agreement on the face of the agreement, whether the agreement in itself is final. And then, of course, lastly, that the settlement agreement is not clear or comprehensible. There are also other grounds that enforcement can be refused, and these have to border on the conduct of the mediator. And such grounds, the two key ones to note are that where there is a serious breach by the mediator of the standards applicable to the mediator or the mediation. There are basic standards. There's a code of ethics for mediators, and where a mediator, especially code that ensure that the mediator is neutral